Welcome to the Risk Roundtable, where claims and litigation management professionals learn strategies to mitigate risk and improve your business's bottom line. Presented by Gallagher, this series delivers industry insights from leading lawyers regarding professional liability, insurance coverage, employment, workers' compensation, general liability, and more. This program should not be considered legal advice. Please consult our attorneys for your specific situation. Thank you for listening, and please visit us at wglaw.com.
Hi, everyone. Welcome to Weber Gallagher's Risk Roundtable podcast. Today, you'll be hearing from myself, Vanessa Mendelewski. I'm a partner in our Bedminster office. And with me on the podcast today is Scott Wilson, who is a partner in our Mount Laurel office. We both solely work in defense for workers' compensation. And today we're going to do a podcast regarding gig economy and independent contractors. So let's get started. I guess the first thing we want to talk about is what is the gig economy? So when we're talking about the gig economy, we're talking about Uber, Lyft, DoorDash, drivers like that. So it's loosely defined as any on-demand jobs, delivery services that you use a company's app or software to connect with others to provide various services. And we most commonly see that, again, with Uber, Lyft, DoorDash, and things like that. So I guess, Scott, the first thing we want to talk about today is worker classification or maybe misclassification before we get into how that deals with workers' comp, right?
Right, absolutely. And hello, everyone. So one of the things that typically happens in this area is there is a dispute between the quote-unquote employer and the quote-unquote employee as to whether the person is an employee or an independent contractor. The courts have addressed this, and fortunately, it's one of the few areas, I would say, in New Jersey workers' comp law where there is really black letter law on what qualifies as an employee and what qualifies as an independent contractor. And what's used in the state is what's called the ABC test. It has 3 prongs, and we're going to go through all 3 of them, but I'll do the first one before throwing it back to you, Vanessa. And the first prong of the ABC test is the employer does not direct or control how the worker performs their duties. Now, this one, it seems pretty straightforward, but it can become the source of a lot of litigation because there's an element of how much is control and how much is just telling the person what to do. So the easiest way I like to explain it is if you're telling a worker what to do but not how to do it, that's probably not control. But if you're saying, listen, I need you to hang this on the wall and put the screws here and do it, you've now established control. And I always, I can't help but do it. I have to tell the story about a case I had many, many years ago where it was this kind of situation. It was a church hired, a sexton for a church hired a guy to come and do some work. And he was Spanish speaking, and an argument developed over whether he was ever an employee. And when he came to court and was testifying, I kept asking him several different questions about whether he was told, what to do or how to do it. And unfortunately, in the Spanish language, although I'm not fluent, I do know a little bit. The word como mean both those words in different contexts. So I kept essentially what he was hearing was, did they tell you how to do it or how to do it? It didn't make any sense to him. So it led to a very lengthy testimony before we eventually figured out that he wasn't being told what to do. He was just giving a general idea. So it really comes down to, the nitty gritty of, are you being controlled in a detailed way about how to do the work, not just what work to do, not just put up drywall. It's got to be how to do the drywalling specifically. And then the second component I'll throw back to you, Vanessa, you can talk about.
Oh, you're talking about whether they perform the duties outside of the usual course of business or perform work outside of the employer's place of business. So in this one, is this usually an activity that the employer does? A lot of these cases come up with, like I said, delivery drivers. Is this a typical function of the business? So a lot of it comes down to very fact specific. And right now we're talking about the ABC test. We'll get a little bit later into the workers' comp test. So this is the second factor, doing what's usually in the course of business. And then the third factor, Scott, you want to talk about that, about the trade and occupation?
Yeah, so this third factor becomes really important. We're going to talk about a case later that became really the crux of the whole case, is whether the work is an independently established trade, occupation, profession, or business. So, if you're having people come in and are doing one task that is, completely vital to your business, it's unlikely that's going to be seen as an independent contractor. But if the person coming on your premises say advertises to do work elsewhere, performs work independently, is able to financially sustain the end of the relationship. All of those things are going to point towards an independent contractor. We will get into later in the case. There's some things such as certificates of insurance. That's not enough. Just if a subcontractor slash independent contractor walks onto a work site and has their own certificate of insurance, that in and of itself does not establish them as an independent contractor. And also going back to the first part, it doesn't matter what you call each other. It doesn't matter if you sign a contract saying you're an independent contractor. The court is going to determine that issue, not the parties. So it's going to really come down to how much of the worker is doing that is independent entirely of the business where he is, typically injured and gives rise to a workers' comp case. Now, maybe if you want to talk a little bit, Vanessa, about some of the signs that make an employee, an independent contractor rather than an employee under the ABC test.
Sure. So some of the signs are: does the person work exclusively for the employer rather than for multiple businesses? So like basically, is it the sole source of their income? Do they only work for them? That's one thing that kind of leads towards, one way or the other on this test. Does the individual the individual does not hold himself out as being available to perform similar work for other clients? So again, they solely work just for this person. They refuse jobs from anybody else. They don't work for anybody else. Do they receive a regular paycheck instead of invoices being submitted? Do they get paid every Friday by paycheck or cash or whatever it may be, versus just piecemeal for the invoices for various jobs? Other things that they look at, this kind of goes to the control aspect you were talking about earlier, Scott. Does the employer provide the tools, the equipment, the workspace, telling them where to go, what to do, the work clothes? Does the employer control the work hours, where they work, or how they complete the task? And again, this is just under the ABC test and worker classification. So in workers' comp, again, we look about whether or not they're an independent contractor or an employee. And we have there were two tests: the relative nature of the work test and the control test. And they kind of have crossover and have morphed into one test, you would say, right, Scott?
Yeah, absolutely. They sort of, the courts generally, the cases I've had, the judges seem to blend the two and apply the criteria for both in determining. And one of the things just those factors you just recited, you can see how fact sensitive these cases are. So while the law is pretty clear in terms of, what the standards are and what the test is to determine it, it's going to come down to most often testimony in these cases as to how many of these factors of the test they meet and are able to show. And one of the cases, this is probably a good time to talk about, is a case called East Bay Drywall versus Department of Labor. It's a little bit of a convoluted case in terms of the procedural history because it was not a workers' comp case. It's actually a case that started out over the issue of unemployment benefits. What happened, just very briefly, is a company was doing business and then stopped contributing to the state to the unemployment benefits, and that triggered an audit. And the Department of Labor came in. This person had 20 people working there, and it was a drywalling company, and they had to make a determination as to whether these were employees or independent contractors. And ultimately, after much back and forth and decisions for both ways, finding no employees, finding some were employees, and finding all were employees, it was eventually determined by the court that they were all employees. And the thing that's interesting about this case is that the court really went into detail about the ABC test and the factors that you want to look at to determine if there is a employer-employee relationship as opposed to an independent contractor relationship. In this one, in terms of like the relative nature of the work test, the company East Bay Drywall was purely a drywall company. They came and just put in drywall on building sites. So clearly all the people that were working there installing drywall were conducting business that was essential to East Bay Wall's existence. So that part of the test was easily established. The control issues were pretty clear that these workers were told what to do. They were given supplies. So it looked like they were going to be employers. Now, the case involved quite a bit of testimony, as indicated earlier. These cases usually do. And one of the interesting things about this case is the court kind of brought up a different, I don't want to say standard, but something to examine. And that was whether the entity, meaning the person who was working there, whether they be joining the ranks of unemployed if the relationship ended. So it's a kind of an interesting way of looking at that third prong of the test, and that if this person really is truly independent and holds themselves out to do business elsewhere and advertises and takes jobs elsewhere and is not just bound to this one job, they're most likely an independent contractor. Now, in this case, there was a lot of evidence, testimony, I shouldn't say evidence, testimony that was given by the employer saying, well, these guys could walk off the job at any time if another job came along that was better, and I had no way to bind them. There was nothing I could hold them. They can go and come as they wanted. And it seems like from the decision that the appellate court was not convinced that that was true. There was never really any evidence showing that anyone ever walked off the job. And in fact, the court said that in itself is not proof of anything, because they said, even an independent contractor, if they turn down work over and over and over again, is essentially never going to get called again. So they said that's not really a determination of whether this is an employee relationship or an independent contractor relationship. So it's something to keep in mind, that there is that way of looking at it, of saying, if this particular worker stops working at this particular job, are they going to be unemployed, and will they be going on unemployment benefits? And if the answer is yes, then they're almost certainly going to be considered an employee.
And Scott, the case you were just talking about was, as you said, not one that was workers' comp. There is a case, Bay Baker versus XYZ two-way radio, which kind of is a bit more comparable to the Uber Lyft driver situation. So in that case, there was a limousine company. They had 450, I think, individual drivers. They each owned a share of the company. The petitioner in that case used his own car, could work when he wanted, made his own schedule. He paid his own insurance. He could take a fare, and then he was placed at the bottom of the list to get another fare. The XYZ, the employer in that one, provided the car and the computer, but there was nothing mentioned about reimbursement for gasoline or repairs to the vehicle. I don't really think that would play into that case or Uber or Lyft situations. And he was free to turn down fares, but then it would be marked unavailable for 30 minutes. And in that case, it came down to, as you said before, case-by-case basis, testimony from the injured worker as well as from the respondent in that case. And in that case, the court kind of looked at all of the factors for the control test. And when they looked at that, they said, well, he wasn't really critical to the operation of the company because they had so many other drivers. Another thing that they looked at was he could make his own schedule. He could turn down the fares. There wasn't much control by the respondent in that case. So in that case, they found that he wasn't an employee. And this is where the scale would tip more in favor of the respondent having a good argument that the drivers of Uber, Lyft, or similar companies, DoorDash, whatever it may be, would not be employees for workers' comp, but would fall into the independent contractor, right?
Correct. Yes. And I think you can see from this that, again, it's fact sensitive. And in New Jersey workers' comp, the judges are the sole trier of law and fact. So they have quite a bit of power in these sort of cases, because once they make a determination, appellate divisions in New Jersey do not start the trial anew on an appeal when it comes to workers' comp cases, unless there's egregious error on the behalf of the trial judge. They're going to basically adopt the trial judge's findings and rulings. So it's really important, I would say, from an employer's perspective, when a case such as this comes in, to do as much investigation as possible to get answers to the questions we were just talking about and the specific factors that the courts are going to look to determine whether it's an employee relationship or whether it's an independent contractor. The more information you have up front, the better your defense is going to be, because obviously at trial in New Jersey, we do not have any sort of pre-trial questioning of the petitioners until they take the stand. Everything is done on the stand. So you don't know what they're going to say. And if they change their story from when the case first started, that obviously puts you in a stronger position from the respondent employer position at trial. So it's really important that an extensive investigation be done and information obtained about as much as possible about those factors we just talked about to leave yourself in a better position to defend one of these claims.
And with all the changes we're seeing with the hiring platforms, a lot of people doing like Uber or Lyft as second type jobs, or DoorDash, You have to also look, like we said, one of the most important things I think in the cases that we have seen is, does the person solely rely upon this as their source of income?
Right.
That's a very big factor that the courts look at, right?
Yep, absolutely. And I think that goes back to what that decision, the last case we just discussed, where they said, is this person going to join the ranks of unemployed? So, if it's their sole means of income, you're probably looking at much more likely the judge is going to find an employer-employee relationship. And again, another thing that's just a broader topic in New Jersey workers' comp is the courts are always going to construe the facts as liberally as possible in favor of the employee to find employment. So unless it's clearly a situation where someone is quite obviously an independent contractor, if it's a shadowy area at all, chances are the judge is going to try to lean towards finding an employment relationship.
And I guess, Scott, the big takeaway from this podcast is, just because the respondent calls them an independent contractor doesn't necessarily mean that's how it's going to fall in workers' comp for New Jersey.
Absolutely. I've over the past 28 years of doing this, I've seen many cases, and I've had some where the employer takes a stand and says, well, we signed a contract where he clearly is an independent contractor, and that has held no weight in the courts. The judges are not bound by that. And because New Jersey workers' comp is remedial legislation that's designed to protect workers, they are not bound to find that because you signed a contract that says you're an independent contractor, that makes you an independent contractor. They do their own independent inquiry regarding all of these factors we've talked about to make that determination.
I guess that's all we have time for today, Scott. So I guess we just want to remind our listeners to go to wglaw.com, where they could find this podcast and other podcasts to listen to. And you could also find our podcasts on any of the major podcast platforms. We want to thank everybody for listening today, and hope you listen to our future podcasts.
Take care, everyone.
Thank you for listening to the Risk Roundtable, presented by Weber Gallagher. We hope you join us next time to learn more about mitigating risk to improve your bottom line. Until then, please visit us at wglaw.com.